1, 2, and 3, each count, you're charged with offender registration violation, a level 6 non-person felony, and that's allegedly April 20th, 2022 in Butler County, Kansas. All three of those counts are a level 6 non-person felony. Those are all the charges pending against you. And could you hear me all right?
Yes. And when did, go ahead, I'm sorry. Go ahead, Your Honor.
No, you go ahead.
No, I was going to ask, when did these charges come about? They wasn't when I first came down.
These were filed on today, September 1, 2023 at 9:24 this morning.
Okay.
Mr. Howell, you do have the right to counsel if you could not afford an attorney. One would be appointed to represent you. Are you currently employed?
No, I'm taking care of my mother.
How long has it been since you worked?
Well, I do work. I cut lawn. I work for my aunt. She's got her own business. I have work.
Do you have any money put back in savings to hire an attorney?
Yes and no. I have, been my mother, with her being sick, me and my brother's going around the clock. They gave her the March to live. And me and my brother been taking turns taking care of her. And so I've been dipping into it, but I got like maybe 500 left.
Okay, well, based on your lack of financial wherewithal, the court does appoint an attorney to represent you in both cases. The court appoints Jim Watts to represent you in both cases. Subsequently, the court sets this matter before Chief Judge Rickey, and that would be on the felony preliminary hearing control docket, Monday, October 23rd, 2023 at 2:30. Monday, October 23rd, 2023 at 2:30 before Chief Judge Rickey. You do need to be present by Zoom hearing at that time. Chief Judge Rickey has previously issued a no bond hold in regards to 23 CR 177, and Chief Judge Rickey has ordered a $5,000 cash or surety bond in case number 23 CR 419. So your bond has been set. Your next date has been scheduled. Counsel has been appointed. Mr. Howell, do you have any questions?
So what's my bond then?
Your bond is on 23 CR 177. Chief Judge Rickey has ordered a no bond hold. And in 23 CR 419, Chief Judge Rickey has ordered a $5,000 cash or surety bond.
So that means I got no bond, correct?
That's what the order from Chief Judge Rickey is, yes.
So when do I gotta wait till October to see him?
You can always file a motion before Chief Judge Rickey for modification of your bond. Otherwise, you would be in the Butler County, or you'd be held without bond pursuant to his order until October 23rd, 2023 at 2:30.
$2,500 bond, I'm held without bond? Over a $2,500?
No, your bond is $5,000 cash or surety in 23 CR 419. You have a no bond hold in case number 23 CR 177.
I know for the previous one that I was on bond, I got a no bond, correct?
Yes.
And that was the $2,500 one. I'm not understanding why wouldn't I have a bond? I did everything right, but missed the court date. I was on no drugs like they said.
Mr. Al, quite frankly, it's not going to be any benefit to you to enter into argument on the bond. These are bonds set by Chief Judge Rickey. The cases have been assigned to him. He is the one that I would look to as far as his judgment is concerned as to the bond.
I know,
So
what did
he's, pardon me?
I'm asking what did I did wrong that I'm not able to have a bond? I didn't have no dirty. All I did is miss the court date, which I had confused. The dates on these 2 court dates, I had 2 different court dates. I had it 2 days off.
Yeah, I think, excuse me for interrupting, but I think right there you have located the reason for Chief Judge Ricky's no bond hold. It was a failure to appear previously.
Yeah, this is my first failure to appear ever.
I'm not disputing that at all.
Everybody else gets bonds, but on my first one ever, on the little non-25, I don't get no bond. But I get a bond on the other one.
Yeah, on 23 CR 177, no bond hold, 23 CR 419, 5,000 cash or surety. You may file a motion for modification of the bond before Chief Judge Ricky.
So who do I go to do that?
Your court-appointed attorney is Jim Watts. Jim Watts is your court-appointed attorney.
My mother's sick and I could be out there.
And I don't doubt you one bit. There being nothing further to come before the court, court is in recess. Have a good day.
Forgive me, Your Honor.
Yes.
McQueen had an afternoon hearing on August 11th, and I believe the court date was changed. And I know
we mailed it to her. I know we did.
That's possible. But I don't.
It's most likely that it's probably absolute. All right. I don't know, Ms. Quinn. I don't have anything on Ms. McQueen. She's an arraignment on the bench warrant.
Mm-hmm.
All right. But she's not gonna be able to be in the bed and go to court. She's not gonna be able to be in bed and go to court. I don't care where she is or what time zone she's in.
Okay.
We on the Eastern Standard Time zone and we're out of the bed.
There we go.
All right, this is case number 214524001. I forgot I went. People of the state of Michigan versus Lisa Monique McQueen. Defendant is charged with operating while intoxicated. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Lisa McQueen. Ms. McQueen, ma'am, please unmute and tell the judge your full name.
Lisa Monique McQueen.
All right. Today is the day set for an arraignment on a bench warrant. As to the arraignment on the bench warrant, Ms. Stevenson.
Thank you, Your Honor. Ms. McQueen stands mute, waives the reading of the information as to the plea of not guilty be entered on her behalf and that the matter be rescheduled for review.
All right, the court will enter a not guilty plea as to the arraignment on the bench warrant. And reinstate the probation.
Okay, thank you.
It looks like she was capiened on August the 11th, and her last review was April the 13th. She is still submitting to your analysis, and at the time of the August 11th court date, she had a balance of $830.
And I believe that's the final condition of compliance. I've asked Ms. McQueen if she wanted to try to have community service, and she's lost her job and is looking for a job. So she would like to have the opportunity to pay. She's doing some DoorDash and stuff like that as to supplement her income, but she's looking for a job and believes that she'll be able to have all the money paid by the final review date of January 12th, 2024, Your Honor.
As long as she's on probation, she's submitting to your analysis. She's aware of that.
Yes, Your Honor. The court did grant a reduction in the frequency of testing due to Ms. McQueen's absolute compliance and cooperation with Ms. Tucker. And she continues to test negative.
All right. Her final review date. Mr. Flanagan, what's her final review date?
There isn't one in the system for
January the 11th at 1:30.
She said no recollection. She's on Zoom.
Stephen Vergaro. What?
That's 1, 2, and 3.
Which girl?
It's 9 o'clock.
Oh, he's here too. He hit a home run on that one. Where is she?
She said she was connected to Zoom. Then she said she had no report.
All right, well, we'll see. Officer Dining, good morning to you. What's your in the breakout room? All right, Miss Crystal O'Neill, are you there?
Yes.
Where's Miss Crystal O'Neill?
Right here.
Good morning to you, ma'am.
Good morning.
It's the city of Detroit versus Crystal Lastar O'Neill, case number SB 1461520, counts 1 and counts 2. SP 3583791, SP 936980, count 2. SP 937282, counts 1 and counts 2. And 13-6313-731. Appearance for the record, please.
Joseph Pernicano appearing on behalf of Crystal O'Neill. State your name for the record, ma'am.
Crystal O'Neill.
Today is the date and time set for a pretrial in the matter, ma'am. Do you have a valid license?
No, I don't.
Didn't I give you an opportunity to get one?
No, I didn't really quite didn't understand. I thought you had to just go to court this day and then see about it. I really didn't understand the first time. I said I didn't really understand the first time. I thought I was just supposed to come to court today and figure it out.
All right. I don't have, she's got a open alcohol in a motor vehicle driver. I don't know if she wants to plead to that or not.
No, I wasn't even drinking. That wasn't even mine. It's not even my car.
Ma'am, the best thing you can do is remain silent, okay?
All right.
And because I don't want you to say anything that could implicate yourself. Now, what you just said is no defense to what this allegation is. You don't have to be drinking to get found guilty of having open alcohol in a motor vehicle, okay?
Right.
All you have to have is that you have to be driving this motor vehicle and have alcohol in the motor vehicle, and the alcohol have been open already. That's it.
All right, I understand.
So by just saying that. Now, the offer is going to include open alcohol in the motor vehicle driving. I mean, strike that. The offer you pled today, which I call a non-offer, is open alcohol in the motor vehicle passenger. That's all the city will go down and on a plea agreement with that. And why do I call that a non-offer? Because it is 2 points on your driver's license. It is, and both of them are going to have 2 points on your driver's license. Both of them are going to have the same $240 fine, and both of them are going to have that alcohol-related offense on your driving record. So there is what the issue is. I'm going to put you in a breakout room, and then we haven't even settled up on the other cases. I would like to see you get a valid driver's license that will put you in a much better position. I'm going to let you speak to Mr. Perkins in the breakout room, all right? And you can discuss with him in a private conversation how you feel and the facts, and you can talk to him about anything about this case, about these cases. And he has to keep that information confidential to you, just you and him. And it will give him a better understanding on how to move forward and advise you, okay?
All right.
All right. I'm going to put you in a breakout room. I'll tell you this too. There's some counties down south, what they call dry counties, that you can't even have a bottle of liquor that's never been opened in your car.
Okay.
So I was like, how you get it home? Hey, they don't want any liquor in your car, period. But Mr. Perricano, why don't you speak to Mrs. O'Neill and let us know what you want to do. You always have an absolute right to a trial, all right, ma'am? That's what my father used to tell me too. Don't talk, you just might walk. Join the room, please. A. Lewis. Is that Adrian Lewis? Did we lose him? He's on mute.
Hello?
Got it? Is that Adrian Lewis?
Yes, sir.
All right, good morning to you, sir. This is the city of Detroit versus Adrian Corwan Lewis. Case number SP 1462959, counts 1, 2, and 3. Appearance for the record, please.
Good morning, Harry Baughman on behalf of the defendant. Sir, please state your name.
Adrian Kawan Lewis.
Judge, this is a pretrial. Good morning.
All right. Today is the date and time set for a pre-trial. They say Mr. Lewis is driving this Mercedes without a valid driver's license and no proof of insurance. Mr. Lewis, do you have a valid driver's license and a proof of insurance?
No, I have proof of insurance, but I don't have a valid driver license as of right now.
What's wrong with your license, sir?
I have to pay a warrant. I have to pay a warrant in Inkster, and that's it. Really, I have to pay a warrant in Inkster and go to the state police, and they have to send something to Lance, and then I can just go straight up to the Secretary of State and pay something and get my license back.
Mr. Baughman.
Yes, Your Honor. We would ask to adjourn pretrial, allow them to bring back a valid driver's license, and what else?
$75 for this failure to stop, but I wasn't really commenting on that. What I was listening to was, first and foremost, he knows exactly what is going on with his license, and he knows exactly what he has to do. He's very, very, very clear on that. But yet, he wants to floss this Mercedes all over Southeast Michigan and probably other states and everything. Now, I don't know whether he had a valid driver's license at the time he got this stop or not. He did tell me that he didn't have one now, but that doesn't mean he didn't have one then or proof of insurance. So there's still allegations. But he tells me that he's flossing Mercedes and Inkster everywhere. But he knows exactly what he needs to do to get a license.
He's gonna pull that money out. Right, Mr. Lewis?
That's what my uncle said.
Yes,
You
sir.
have to pay the costs and be the boss. And when you ride Mercedes, you the boss. Aren't you, Mr. Lewis?
I ain't gonna agree with that, but I'm gonna take care of it. I'm gonna take care of it for you.
You're not gonna agree that Mercedes turns heads and all that stuff?
It do, but yeah, I got you, Yard.
That's not a true statement.
Yeah, it's true.
So you the boss. When you're in that Mercedes. At least when you're in that Mercedes.
Yeah, I look good. I do look good. All right.
See? The truth comes out. That's what you call cross-examination, Mr. Bachman, you know.
I hear you, Your Honor. I am taking notes, but let us not lose sight of the fact that this is not the type of attention you want, right, Mr. Lewis?
Right.
I think that that's what he's trying to convey by being hesitant on his answers. He's not proud of, he's not necessarily proud of that. I'm not saying that he is. I'm just speaking matter-of-factly here. Matter of fact, when you pull up in a Mercedes Benz, heads are turning.
Right, but I'm not no show off, Your Honor. I'm just driving.
Well, by definition, you're a show off. Mercedes Benz says that.
The light was yellow.
When I pull up in my Grand Marquis and you pull up in your Mercedes Benz, who do you think they're gonna look at first?
They probably look at mine first. They probably look at mine first, but your car probably all right too.
And that's why you got it, isn't it?
Yes, sir.
Case closed. Come back October 9th, 2023. Hopefully you have a valid driver's license, valid insurance, and $175.
All right, I got you.
October 9th, 2023 at 8:30. All right, Mr. Lewis, thank you.
You too.
All right.
Sarah Marco Zavala. Do I have someone from the state and probation? This is no application. Court is calling 2022 CR 10023, State of Texas versus Marco Zavala. Can I have parties announced for the record for the state? Defense. And are you Mr. Zavala? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Zavala, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented?
I believe so.
Okay, let me check. It appears you are. Mrs. Zavala, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with theft under $2,500 enhanced? That's a state jail felony. The range of punishment is anywhere from 180 days to 2 years in the state jail facility. I'm going to need y'all to be quiet in the box. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Before we continue, counsel for state and defense, it appears that the judgment and the indictment 2016 CR 4303W, there should not be a W on that in the indictment. So is there any motions to amend?
Yes. Is it just like,
I don't know. So in the judgment, for the evidence that's being presented to the court, it's 2016 CR 4303. And the indictment is listed as 2016 CR 4303W. Sure.
yeah, should we would move to strike the W from the indictment?
All right, Mr. Zavala, did you understand removing the W from the indictment? That's a substantive change to the indictment. All right, did you understand that your attorney has 10 days to prepare for trial? Are you giving up those rights and are you wishing to continue forward with this plea bargain agreement? All right, counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Zavala, has anyone threatened you? Zavala, has anyone threatened you, coerced you, or placed you in fear? Thank you, to enter this plea. Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 6 months in the state jail facility and there are no applications. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, sir.
State?
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No cost.
State any evidence.
Yes, Judge, state exhibit 1 and all.
Mr. Zavala, I just want to add things to that name. I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
This court would ask the court to follow the plea bargaining agreement and ask for the obstruction.
All right. Court will follow your agreement, sentence you to 6 months in the state jail facility, and give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, sir.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. How old are you?
42.
All right, you're 42. You have decisions to make. And your decision that you need to make is, do you want to spend the rest of your life in and out of jails, in and out of prisons? And you're getting to the point with these theft cases that you're going to soon be looking at habitual status, which means that your range of punishment may be from 2 to 20 years. Being a thief or theft as an occupation, I know it's glamorized sometimes in movies like Ocean's 11 or It Takes a Thief. And I know when I'm saying It Takes a Thief, I'm aging myself. You probably don't know what that is. But theft is not an occupation. If you want something, go get a job, right? And if it's not worth you having a job to get it, then it's probably not worth having. You understand? All right, you're going to have to do better. Otherwise, you're going to keep coming back and forth. All right, good luck to you. Thank you. Who's here on